Adjournment only with the consent of the other side of it. I have two adjournment item number 2 and 3.
Please give it.
Yes. Lordship, item number 13, my lord. We have some adjournment. No, Lordship. Actually, item number 13, my lord. There are some recent development, my lord. We want to withdraw this petition with the liberty to file afresh, my lord.
Let the item call, we'll pass the order. Let the item be called, we'll pass the order. Yes, item number 1.
Item 1 for motion.
When the matter was listed on 18/10/2023. It was taken note of by the order of the court that this is the second time the petitioner is before the court. No, it's not the second time in case. Yes, what is the information, Mr. B. Dewry? They're coming for the same cause that their application was not placed before DLC for a second time. Yes.
Second time filed with the application.
We pass the same order.
Yes.
If not placed, place it. If placed, inform him. None appears for the petitioner.
Infectious.
Infectious. Mr. Your name?
J.M. Sulaiman.
J.M. Sulaiman, and counter petition states that the matter has become infectious, no education required, writ petition closed.
Item 4.
Back get appearance did you? 239.
2-3 adjourned.
Your matter is adjourned.
No, I have mentioned Lordship that 2 and 3. That Lordship directed Mr. B. Kosi to produce some records were with him, Lordship, because he is not felt well in the morning, Lordship.
Okay. Okay.
That is the reason.
Some other day.
Yes.
Yes, item 4.
What is on 18/9/22? Petitioner was directed to show the page number which contains the recommendation of PLC.
It's not a direction, it is your requirement.
Yes.
When you make a submission,
Yes.
you are required to at least tell us the page number which you are referring.
There are 7 I have mentioned.
We don't know what is the matter about.
Date is not there, man.
What is the matter about?
Text to correct. Matter relates to
Passionate.
SLC have rejected the deal.
SLC rejected. Which page is the DLC?
PLC minutes I have not annexed. That is.
Where is the name of the petitioner? No, this is not him.
Only one column is there. Name
Was he recommended or not? Just see. And where is SLC page number?
Page number, my lord.
Hmm.
See, my lord.
Page number 19.
Page number 19.
What is the name of this man?
20 is the relevant page, my lord. Column number 2, my lord. This one are. Number 1 is the petitioner, my lord. Three Nitin Newpan.
And Mr. Sakya, what do you mean by page 20? Rejected due to non-availability of NCT norms. And also do not come under purview of OM dated 2/6/2017. HS below 45. What is that 2/6/2017?
Otherwise, my lord, if he is not eligible for assistant teacher, then they may recommend it for any case.
No, no. What is that 2/6/2017?
17.
Do not come under purview of OM 2/6/2017. So what does it mean?
No, regarding percentage must be
No, percentage I understand. Less than 45, not fit for teacher. But what is 2/6/2017? Do not come under the purview. Find out what it is.
My lord.
Tell us after some time.
My-
What do you mean by 2/6? Does it mean that a person died after that cutoff date when compassionate appointment was withdrawn?
Is, one.
Don't say anything on presumption, actual facts. huh? If it is so, I'll have to pass a different kind of order. If it is not so, another kind of order will be passed. So please tell the correct facts. After.
Item 5,
my lord. The petitioner is specially able candidate.
Specially,
Able candidate.
okay.
As per an advertisement,
So now what is your prayer? Appoint you cannot get that way. Why should you be appointed?
my lord, petitioner is already selected by the authorities. My lord. He is placed on, my lord, 942 rank, my lord. And he is selected for the post of, my lord, 942, page 32, man.
Page 32.
Ramesh Chauhan, my lord.
Page 32, yes.
942, man.
No,
Yes.
you're referring to which page?
Page 38, my lord.
38.
Yes.
38, yes.
Column number 940, 942, my lord.
That Kamsar Basumotari.
No, Ramesh Chauhan, my lord.
There are a number of 942.
Yes, my lord. Ramesh Chauhan. is the
Ramesh
petitioner.
Chauhan, huh? So why you should be
He got
appointed?
selected, my lord, but no
No,
appointment order has been issued.
No, no. Are you selected on merit?
Yes, my lord.
How do we understand that
As-
is a
As
selection?
per the my
No,
advertisement.
at least give the first page of the order. This may be just a merit list. It may not be a select list. Copy is merit list.
Yes, it's the merit list.
Huh. So if it is merit list, that does not mean automatically you are selected. Suppose the available post is 900. 942 may not be selected for appointment. So you have to give some more information.
My lord, whether they have selected the petitioner or not. till
How
date-
do you know? It is for you to tell us.
Yes.
This is not a RTI application
Yes.
that I don't know anything. This is what I know. Please ask them what is about. We can't convert a 227 petition for a petition seeking information. Give us some more information. Tell us the advertisement. Tell us the number of posts that were available. If the number of posts available is more than 200 and 942, then we'll understand, yes, you may have been selected. Again, And you are just putting one page from in between. I don't know even what is this document about. It's only having some numbers and some names.
My lord, is the merit list given by the.
It is
coordinator?
your statement. Why don't you give the whole document? Let us see. How do you expect a court order to be passed based on just one page of a document? Neither the heading is there, not. Mr. Upadhyay, when your client came to you, your first question ought to have been, give me the whole of the select list. Let me examine. What kind of a list is this? Second question ought to have been, if your number is, serial number on merit is 942, how many posts were available for appointment?
There are
If the
several
number of
numbers.
posts is more than 942, definitely you have a legal right. But who will provide this information now? Why did you file this petition in this without any information?
My lord, on the next date, I will.
Writ petition is not for making a roving inquiry, no? That I'll issue notice to then make an inquiry, then find out whether you have a right or wrong. Minimum information should be from the petitioner. What do you want to do? Adjourn. The petitioner refers to the page 38 merit list for locomotor disabilities, including cerebral disability candidate, which is page 73 of a particular document. The complete document is not produced to enable the court to examine as to what kind of a list is page 38 a part of. Petitioner merely claims that as his name appears in the said list, so he has a legal right to be appointed. Further information would be required as to under which advertisement the petitioner had participated and what are the number of posts available for appointment. Mr. Upadhyay seeks for an adjournment to provide the said information. When do you want?
I leave.
Item 6.
May I please, Your Lord. Matter pertains to my lord compassionate appointment, my lord. SLC has rejected, my lord. DLC at page 23, my lord.
Page 23 is the DLC.
DLC, my lord. My lord. He is at serial number 1, my lord, of people Islam.
Just a minute.
Page 23. Serial number 1 is.
What is the name?
Rafiqul Islam.
Rafiqul Islam.
Hello. In the above para, my lord, it was mentioned that the proposal has been sent to the SLC for consideration.
This is not recommendation.
My lord, for
No, you
consideration-
read that serial number 15, Jahirul Islam.
My lord, the below para, my lord.
Mr. Hazarika.
My lord,
No,
in compliance of the,
I understand.
I'm reading.
Please read the serial number 15. Hazarika recommended
But in
Rafiqul Islam. Okay, Rafiqul Islam in compliance recommends the proposal. Then who appears? DLC. Mr. Saikia, you appear. You appear for DLC. What do you mean by this one? Come to page 23.
My lord.
In compliance of High Court order dated so and so, DLC recommends the proposal of Rafiqul Islam for appointment on compassionate appointment. Against what post? Where is the identification of the post? This is number 1. Number 2, then the next paragraph, after examining the following proposal, DLC decided to forward the proposal from the strength of post of to the office of the inspector as per rule 15 of the say and request the concerned department to take up the matter between them and accordingly submit proposal for consideration. What is this? Both are self-contradictory. Once you say you are recommended,
And next,
then you say
take up with the concern.
submit a proposal. And where is the SLC?
My lord, SLC at page 29, my lord.
Page
Uh,
29,
is the serial number 6, my lord.
6. What the SLC had done.
Lack of vacancy, my lord.
What will the SLC do if you don't identify the vacancy and recommend somebody? What do you expect of the SLC to do over it?
15 posts. That means total vacancy filled in the district.
Why the deputy commissioner is not doing his duty? And these are requirements of law. DLC is a entity created by law, by a court's order. And he is required to do in a particular manner.
That is
We
why
don't want a bureaucratic language for that it is neither here nor there.
identification of vacancy is there.
When the court requires, ask him to do it as per the requirement of the court order. He's from here is he? Kamrup, ask him to come. Ask this man to come wherever he is. He must be deputy commissioner elsewhere, if not in Kamrup. Again, he'll do the same thing somewhere else.
Now, the rule is there.
Yeah, are you not unnecessarily harassing the citizens? You should take up at it true earnest. You find somebody not entitled, reject it. If he's entitled, give it. But what is this kind of thing? 14 DLC recommends, you don't even identify which post is or to which post is recommended. Then you say, after examining, decided to forward the proposal from the strength of post to the office of inspector as per rule 15 and request concerned to take up the matter between.
PLC have to take this 10th of post, how many posts vacant.
It is their duty.
They have sent to their inspector.
Yes, Mr. Hazarika, possibly you will have to send it back to the DLC to redo the whole thing.
My lord.
And you pay a cost for harassing the petitioner. Had he been appointed on compassionate appointment, what would have been his salary? Had he been appointed, how much would have been the salary?
Get poll.
Even if it is 10,000, I think it will be much more than that. Even if it is 10,000,
At least 20,000.
you have unnecessarily harassed this man from 12/10/2015. Pay 10,000 every month. What else to do? Let the deputy commissioner pay it. Had you rejected in the first instance, he would have known that yes, no
No,
commercial appointment is available for me, I'll go look somewhere else. But because of this thing, you are only spoiling the career of a young man. Think over. We intend to impose some cost. Ask the deputy commissioner why he had done that.
in this case,
Sorry,
allow me to obtain inspector, my lord, if 15 posts is available, my lord.
I don't know. You do whatever you do. We'll take him after some time.
Any other test? Otherwise, we can-
Why should I list it once again? Then you pay for the cost of listing. Firstly, the respondent will not do their work.
that is-
Secondly, you'll put a citizen to his detriment. Thirdly, you again want time. Yes, Mr. Chisti, what kind of advice you are giving?
The Department of Education, the Department of
And something is there in page 22 as regards the number of posts available.
That is in regard to the other person, Lordship.
Hmm.
In grade 4, regarding one Korgeswar Kolita and one. Designate. Regarding grade 4, there is a total strength of grade 4 was 2. On compassionate ground is 2. 2 numbers of post, grade 4 posts were there. And, huh? It's agricultural. It is good.
Then who had sent this one to the SLC? DC ought to have sent it to the inspector if he is asking for more information. Why did he send it to the SLC to be rejected? After some time, tell me how much cost?
Item 7.
Obliged.
That is permit, my lord, take it up any other day, so that I can get the.
Then adjournment cost of 10,000. Wait.
Because DLC report, Lordship, the whole report is not annexed, Lordship, the first page and the complete. Lordship.
Whatever is there, we can
Even
get
the
it.
Previous, page number 11, there may be some information may be there, Lordship. Because it was.
No, even if there is information,
Yes.
what is there in the relevant available page, that itself is self-contradictory. On one hand, you recommend, and on one hand, you say something different. And then send it to the SLC,
15.
knowing very well that it will be rejected straight away. Ask the DC office to send the complete DLC if you want. Email. Ask them to scan and mail it. Yes, item 7.
Obliged.
The last order, my lord.
Some order was passed on 23/11/2023. List on AK video for the information as required by the order dated 23/11/2023.
Item 8.
The man who you had given the in charge headmaster,
Yes, yes.
from the list that is on record of the court, it does not appear he has B.Ed degree.
Yes, the information is there, Lordship, Wednesday, Lordship, yes. I couldn't print out that copy from my WhatsApp, Lordship. I'm sorry.
If he does
Yes,
not
yes.
have B.Ed, we should stay that order. If he has B.A,
Yes.
inform Mr. Prakash.
Yes, sure.
Item 8. So we have filed an affidavit today itself, madam.
Has it come on record? It's stated by Mr. T.C. Sutial and counsel for the Saver that an affidavit has been filed as required by the order dated 29/11/2023. Affidavit not on record, list along with the affidavit.
Item 9.
Maybe. But the impugn order is at page 65, my lord. The second time is rejected on 2 grounds.
65.
Yes, sir. One ground is he is not having NOC for pursuing the higher education. And another ground they have stated, my lord, that he has not completed graduate service as a graduate teacher in the higher secondary schools, my lord, for 17 years. But in
Just
that-
a minute. What is the relevance of the High Court order in page 67? Why did you annex it?
My lord, this is with regard to NOC is not required. Your lordship has settled the position, my lord. NOC for pursuing the higher education, my lord. That the second ground they
That is not required, that
Yeah.
is okay, but how does it has relevance here?
they have in this paragraph, last paragraph, they have stated, my lord. However,
Why we should not draw up contempt against his director for repeatedly taking the same stand? And the High Court is repeatedly reiterating that it is not required. This is dated 1/11/2023. Does the director think that in every case the High Court is required to pass an order? Why, she doesn't like to follow the High Court order or what?
I think it is also, we have also failed to, it is our duty also.
No, the law is settled long time back. It is at least 2 to 3 months by now.
Yes, yes.
yes,
Immediately thereafter, we understand, yes, the director may not be aware of the law laid down. But I think after 3 months, the director ought to be aware. Why you are repeating the same thing again and again? The director of secondary education, Mamta Hosai, to show cause as to why, in spite of there being repeated judgments by the court, that no NOC under the law is required to pursue higher studies of an in-service employee. And no, there's no required, that key in spite of the key.
In spite of there being repeated judgment by the.
And that a higher degree obtained without obtaining NOC is not an invalid degree under the law. Full stop. Reply of the director to be placed on the court on the next list Wednesday. Ask her to file the director to file an affidavit. Now she'll at least come to know.
Yes, yes.
Let her file an affidavit. Why she is and why the act of the director should not be construed to be a violation of the court order.
Item 11.
My lord, petitioner has been serving as a part-time lecturer for last 16 years. She is otherwise qualified for appointment on regular basis. The principal of the college, Farugate College, also sent the particular.
Director to take a decision on the claim for adjustment of a serving vacant post.
Then, my lord, that page 26, this honorable court directed the director to take a decision within 3 weeks. Operative part is Page 27.
Yes, Mr. What do you say?
Lordship, there might be some decision, Lordship, that has been taken,
Might be some.
some decision taken pursuant to the.
Don't act on the advertisement then.
Yes.
Don't act on the advertisement.
Till December.
Because there is a high court order requiring this person to be considered against some post. Don't fill up that post by some any other advertisement.
Lordship, can this matter be taken up on Friday, Lordship?
No, why?
We can, but we are also passing an interim order. Heard Mr. N. German and counsel for the petitioner, also heard Mr. D. Upamidun and counsel for the respondents in the education,
Higher.
in the higher education department. Where is the court's order?
Lordship, page 26. Cooperative code.
Page number
26, Lord.
26.
Paragraph 4.
By the order dated 6/11/2023 in WPC
6405.
6405/2023, a direction was issued to the Director of Higher Education Assam to take a decision in connection with a notice issued to the petitioner dated 12/9/2023. By which the petitioner was called for a hearing on a claim that. What is your claim, Mr. Sharma?
My lord, for adjustment, my lord, because I am
For adjustment against the vacant post
in the Department of History.
in the Department of History.
Assistant Professor, name of the post, Assistant Professor.
In the present writ petition, a grievance is raised that without giving a consideration as required by the order dated 36/2023 in WPC, 6/11/2023 in WPC
6405.
6405/2023, an advertisement was issued dated 17/11/2023 for filling up the said vacant post in a regular recruitment process. As a prima facie case has been made out by the petitioner for a consideration of his claim based on a judicial order of the court, comma, the balance of convenience would be in favor of the petitioner as well as the petitioner suffer an irreparable loss is the advertisement dated 17/11/2023 of the principal Kharupetia College is not stayed. Accordingly, the advertisement is stayed until further orders.
Lordship, only in respect of
In
Department
respect
of
of History
History.
Department.
In
Because
respect
there-
of the
History, Department of History.
of one post in the history department.
Hello.
You dispose it off and go ahead. We'll recall the order. Day you say I have taken a decision.
Yes, Lord.
Whether you allow or not allow is your discretion.
Yes, Lord. Obliged.
Item 12.
Yes.
Lordship, the petitioner hearing is the president of Bhangnamari number 2 Bhangnamari LP School.
Notice 4 weeks, take away 30 notice.
Your Lordship, he is the president of the school managing committee, Your Lordship. His committee was approved on 29/6/2021. Your Lordship will find on page 13.
So you are agreed by?
Your Lordship, I am agreed by the impugned letter dated 5/9/2023 by the district elementary education officer Nalbari.
এইটোৰ আগতে এটা দিছো নেকি অৰ্ডাৰ? এই কোনোবা এটা SMC 3 বছৰ হোৱাৰ আগতে জেনেৰেল নোটিছখন যে এপ্লাই কৰি দিয়ে। দিছো। Heard Mr. I. Hussain, learned counsel for the petitioner, also heard. And Bhupan, learned counsel, elementary education department. The SMC of which school?
Your Lordship, number two, Bhangnamari LP School.
Hmm.
Number two, Bhangnamari LP
Now,
School.
number two, Bhangnamari LP School was constituted as per the communication dated 29/6/2021 for a period of 3 years. But the grievance raised is that as per the common
Annexure three, Your Lordship.
communication dated 5/9/2023 requiring reconstitution of the school managing committee, the committee of the petitioner school may be reconstituted without allowing it to complete its tenure of 3 years. In view of primacy made out there, it is provided that the communication dated 5/9/2023 shall not be made applicable to Bhangnamari Omukomo till the school completes its tenure of 3 years. Notice 6 weeks, extra copies 3 days.
13,
Yes, after 6 weeks.
Lordship, Your Lordship, if the operation of this impugn letter may be stayed, Your Lordship.
You don't want our order. Okay, we recall our order. If you're not happy with the order, we
Your
are.
Lordship, I just. This.
Lordship, I mentioned it, the matter for withdrawal with the liberty to file afresh matter.
Sorry, withdraw and file afresh.
Afresh.
Mr. D. Borua,
PK board.
PK Bordoloi. Bordoloi Land Council states that the petitioner do not intend to pursue this
Some
petition in the
developments are,
present form with liberty to file afresh. Prayer allowed, petition allowed to withdraw, liberty granted to file afresh. Mr. Government appears for the Higher Education Department, sir.
item 14,
May I please, Your Lordship? DLC rejected the case.
Page
of the
number
Typed copy, Lordship, relevant page 28, Lordship.
28. Where is it?
Page 28, Lordship.
28, yes.
Yes, serial number 4, Lordship.
Biswajit Bayon.
Yes, Lordship. And original page 32, Lordship, DLC page.
Heard Mr. N. Hussain, Land Council for the petitioner, also heard MS N. Phokan for the Elementary Education Department, Mr. P. Saikia for the Deputy Commissioner Kamrup. The father of the petitioner, Joydev Bayan, was serving as what was he
Assistant-
working as?
Assistant teacher. of
As
Samori
assistant teacher in the
Samori Upper Primary.
Samoria Upper Primary School, died in harness on 28/10/29, and on his death, his wife submitted an application for compassionate appointment, which was rejected by the DLC in its meeting of 27/3/2012. The petitioner Biswajit Gayan was a minor at the time of the death of the deceased, and upon attaining majority, he had made an application on 20/10/2021, which was rejected by the DLC of Kamrup district in its meeting of 31/12/2021. The law regarding the submission of an application by a minor upon attaining majority in a circumstance when the widow of the deceased had earlier made an application but rejected is settled by the Honorable Supreme Court, Khadim so and so. In view of the law, proposition law laid down by the Honorable Supreme Court in Khadim Supra, the reasoning of the DLC to reject the application or a petitioner made on 10/12/2021 is not sustainable in law. Accordingly, the rejection set aside, remanded back to the DLC for a fresh consideration in terms of the law laid down
Yes, sir.
in Khadim to be placed before the next DLC.
item 15,
Second petitioner, Lordship, petitioner applied, but the DLC has not placed the application of the petitioner.
Place it, and if placed, to inform you.
Obliged, Lordship.
16,
Please, my lord, matter pertains to compassion appraisal.
Yes.
My lord would find the representation as.
No, was it placed before DLC?
No, my lord.
Same order. Give the particulars, huh? Name of the deceased, date of death, date of application.
Highly object.
Huh? Please.
Item 17,
Yes, Madam Saikia.
This case, my lord, they have approved this case earlier also, my lord. And page 62 judgment is there. And my lord, it's relating to my lord, registration of some subsidies, my lord. Relevant
Direction
paragraph,
should be issued, call for a hearing the party set aside, cost the order dated.
this one I put.
paragraph 22.
What is this NEIDS 2017? Some scheme.
That is a scheme, my lord, for needs,
Scheme for what?
scheme for giving subsidy, my lord. That
Subs-
is in the registration itself.
And by the impugn order, it was rejected.
Yes, my lord.
By
And
which page?
across this court,
Which page?
earlier input order, my lord. That is my annex, my lord, I have annexed the.
Yes,
judgment.
we are issuing notice.
Yes, my lord. I listed notice.
AK Doctor for, you are for whom, Mr. Doctor? You are appearing for,
Meaning for Indian people.
no, who are they? For the Union of India?
Yes.
For response number 1 and 5.
Your name?
N Khalid.
N Polita for the Industries and Commerce Department, Government of Assam. Notice 6 weeks, extra copies 3 days. Any private respondent? No.
No, no.
Extra copies 3 days. In the interim, it is provided that the application of the petitioner claiming for registration under the NEIDS 27, it's provided that consideration of the application of the application claiming registration and needs shall not be a bar due to the pendency of the present writ petition.
Item 18,
In the, it is, in the interim, it is clarified that will be provided.
Problem.
My lord, sir, time being for this matter.
Sorry.
Time being for this matter, my lord. sir.
Time.
19 for admission.
Yes, more juice. Which way it is going?
It's very embarrassing for me. my lord. They could not say it here last week. So can it be taken up on Thursday? Thursday, definitely.
But please do it, because otherwise I'll have to close this matter in some way.
My-
If you don't do, maybe I'll have to hear it.
Right.
Well, after continuing for almost 6 months now, it's not proper to
Right.
not to conclude it.
If it doesn't come within Thursday, my lord, then
Or should we issue a direction?
let us see it in Thursday.
Otherwise, we'll issue a direction to take a decision. That's all.
That is better.
And we'll refer to the other ones
Yes, lord.
where the Supreme Court has approved it. So as a similar claim is made in the state of Assam, you take a decision, put it up before the legislature, what you want to decide.
Let us see in Thursday. my lord.
I think we can always direct the authorities to place it before the legislature. That I think 226, we can do it. Just check up whether we can pass that order into 26 or not. Directing the executive to place it before the legislature for whatever decision they take. Or it cannot be done, possibly.
One or two sentences are there, basically.
No, no, we are in a situation where Supreme Court had put a complete bar. Then subsequent situation is to overcome that some of the states had passed the
Yes, yes.
statute, enacted a legislation allowing it in a, of course, restricted or controlled manner, whatever it is. When that was challenged before the Supreme Court refused to entertain that the state can do it. So this dispute is that you are preventing them. Okay, saying that relying on the earlier Supreme Court judgment. Now, because of the later judgment, the position has changed to some extent. that the legislature has the discretion to take a decision. So if the legislature has a discretion to take a decision, why the legislature will not take a decision?
That can, to that extent, it can be.
By not taking a decision, is the right of the petitioners not being violated? Hmm.
On Thursday, Thursday.
But there also it was same thing where Supreme Court long tradition, this, and ultimately the legislators said that do it in a little restricted manner, put in some more provisions where the welfare of the animals are also taken care of. Or else taking note of the principle ultimately that the Supreme Court had taken. Supreme Court had approved the legislature allowing it in some restricted manner. If the legislature or the executive does not take a decision, I think we can direct the executive to take a decision in a restrictive manner, or the circumstances are such that even in a restricted manner, it cannot be allowed. That means the reason for rejection will now be on the executive. You cannot rely on the Supreme Court judgment and say that we are not allowing it. It will be more
Since
difficult.
you have the discretion.
Huh.
I understand. I'll place it before Lord on Thursday.
Can't we look at from that point of view? That ultimately what flows from both the Supreme Court judgments, that if a decision is taken by an appropriate authority, imposing certain restrictions, this can be allowed in a limited manner. Ultimately, that principle flows from the Supreme Court judgment.
Take it then.
Now, if the state authorities don't take a decision, either placing it before the legislature or they themselves take a decision, and you rely on the earlier Supreme Court judgment, that because of that reason we are not allowing, that will be little unacceptable. But if you exercise your discretion to refuse on some other reason, not on the Supreme Court judgment, that factually this is unacceptable for this reason, it's a totally different matter. But now you are relying based on Supreme Court judgment, not on your own decision. So we may direct requiring you to take your own decision on this. You use all scientific methods, all other law, everything.
I'll come back on Thursday.
Because the stand of the state is, state has not taken any decision till now. State says only
Supreme Court.
Supreme Court.
The Supreme Court is-
So, because of the change circumstance, now we will require you to take a decision. Divorce the Supreme Court judgment, whether for other attending facts and circumstances, whether it is should be allowed, should not be allowed, if allowed, in what manner to be allowed.
My lord, I'll give you.
Madam Chaudhary, you also please just examine that. To what extent a writ court has the power to issue this kind of orders?
20 and 21.
Yes, Lordship, Lordship directed us to file an affidavit, we had sent it for vetting, Lordship.
Adjourn on the prayer, Mr. Assembly Chief Justice and Counsel for Elementary. Secondary, sir, for it is stated that the affidavit is set for vetting, it will be listed, it will be flight shortly,
Yes, Lordship, yes.
a list after a week.
I'll put it.
23.
Sorry.
Lordship, here also I have seen that.
Yes, to produce the complete
some
records of
records, yes.
NAPOMUA to enable to examine who between the will be senior science teacher. You have the records?
No, Lordship, that. we need
Mr.
some-
Assembly Chief Justice and Counsel for the Elementary prays for some further time to produce the complete records of NAPOMUA ME School of Jorhat District as required by the order of 21/11/2023.
Yeah,
List
I'll
after a
get it.
week.
I'll get it.
All right.
24.
Yes, Mr. Motin.
Maybe your lordship. This matter came out last time also, madam, they have taken time. Your lordship, this matter, your lordship has gone through this stage earlier, madam. This is the third round of litigation, madam. Your lordship is at page 56, there you elaborate order, madam.
Page number?
Page 56 is start, madam.
No, this is a new writ petition.
No, no,
No, no.
yes, that was the earlier one. There was a direction from this honorable court
Mm,
to provincialize the service of the petitioner
The
with effect
person to
from
be
the date
ordered
of
the
the.
director of the provincial service of the petitioner as grade 4.
Lordship.
Najib Memorial Guide. Lengthy Singer. This college is very, internal affairs of this college is not very good.
Because we are victim of that one. I am
Understand that Rajiv Gandhi Memorial
victim.
Lengthy
I am
Singer.
victim, my number, serial number 1. In spite of that, what they say, I have not submitted my form.
Yeah, we are
so
getting a
they-
number of litigations on this college.
Lordship, before my senior counsel starts, Lordship, can I pray for some time, Lordship, in this matter, Lordship? Can this matter be taken up on Friday, Lordship? No. Because, Lordship, Mr. K. Gogoi will appear in this matter. Today he has some difficulty, Lordship.
Last day, my lord, all right, my lord, he is the.
Mr. K. Gogoi will appear.
Again and again, you are taking time. And your lordship is very much know of this matter, my lord.
Anyway, what is the, let us understand the matter, we'll adjourn, no difficulty.
Yes, your lord, kindly see page 58. RDR, my lord, or page 45, my lord. RDR, there is direction from this honorable court, man. Page 58.
You are
your lordship.
the province, you are pursuant to the order, director provincialized the service of the petitioner under the 18
Yes.
Act, a salary of so and so.
Page 58, your lordship's order.
They rely on some state of Manipur versus Suraj Kumar.
Yeah.
That if the statute is declared to be unconstitutional, it becomes void ab initio.
That is the. But here is a case where the direction was given under that you also observe, my.
But,
is not that kind of-
but Mr. Upamanyu,
Hmm.
regarding why Surya Kumar Okram will not be applicable, yes, you are right in saying so. If an act is repealed, it will be prospective from the date of appeal. Earlier actions taken will be saved. But if a void is declared unconstitutional, it is void ab initio, as if from the beginning, it is a void legislation. So no rights can be claimed under that. But while declaring it to be void ab initio, later on review, there was a clarification by the same court that whatever actions had already been taken are saved. Because of that subsequent provision on review of the same judgment by which it was declared unconstitutional, whatever actions had already been taken, they are saved. So your Suraj Kumar Okram will not be applicable. Thursday. It appears from the order dated 9/5/2023 that the respondents in the higher education department relies upon a judgment of the Honorable Supreme Court rendered in state of Manipur and others versus Suraj Kumar Okram and others decided on 1/2/2022, wherein it is provided that there is a distinction between the declaration of a statute unconstitutional by a court and the repeal of a statute by the legislature, with further provision that on a declaration of a statute as unconstitutional, it would become void ab initio, meaning thereby that all actions that are taken or pending under the statute declared to be unconstitutional are also void ab initio. But in the instant case, it is noticed that the Act of 2011 had been declared unconstitutional by the judgment dated
dated 23/9/16.
23/9/16 in WA, I think, no, W or
WPC
WBC.
number 3190
In W1 3190
of
stroke
212.
of stroke 2012. But at the same time, subsequently by another order dated, you have the information, the review order.
We can get it, but.
By order dated so and so in review petition so and so, the same court which had declared the statute to be unconstitutional had provided that all actions taken under the act declared to be unconstitutional are sealed. The responding higher education department to respond on the said proposition. Mr. Thursday as made for.
25 for orders.
Highly open.
We directed the complete records of the selection of library in Rongia Arabic College to be produced. Do you have it?
Record. I inspector can some record, but not the whole record.
By the order of 21/11/2023, the complete records of the selection of the respondent was fixed to the post of librarian of Rongia Arabic College was required to be produced. Today, Mr. S.M.T. Chisti learned Planning Council for the Secondary Education Department has produced certain records.
This is regarding that appointment response 6 also, how we are selected.
Oh, who is respondent 6 name?
Raza Kabir.
Raza,
Raza Kabir Latif.
Raza Kabir Roy,
No, it's only Raza Kabir.
Raza Kabir.
And this.
Just a minute, where is Raza Kabir?
Latif
Phase
Mechanic-
4, your lordship, of the petition.
No, your page 4, but here in
Here
this
the
one,
last page Latif Mechanic, see, last page Latif. 16, serial number 16, Raza Kabir.
Raja Kabir, huh? 39 years, total so and so, PC 37 marks. And who is the petitioner?
Petitioner Latif,
Nidul Haq,
Middle Hawk is in serial number 13.
13.
Yes, sir.
Nidul Haq got 109 marks.
Yes.
And Raja Kabir got 113 marks.
13.
Your lordship, that there is the your lordship dispute between calculation. My certificate for library has not been counted, your lordship, and he has been given.
Where is a library certificate? Which clause is library certificate? Library?
There's a remark Latif against Middle Hawk that certificate of CMJ University is cancelled. It's cancelled.
Cancel. Huh?
Yeah.
CMJ, they don't
Your lordship,
accept
there
it.
is- I don't think any, your lordship, the library certificate and graduation certificate of this issued by CMJ college are, your lordship, not.
May not
accepted,
be, they're not accepting your certificate.
Your lordship.
CMC certificate for which qualification?
Yeah, librarian, your lordship.
Library.
Library science, library.
So you are not even qualified in library science. If your certificate is cancelled, not accepted,
Your lordship, even then, your lordship, my mark is higher, your lordship.
your mark may be higher, but your qualification is rejected.
He doesn't
Yeah.
have any, your lordship, library science,
You challenge it. Who does not have?
the private respondent
Does not have.
doesn't.
So when we have to examine one man having a certificate which is cancelled, rejected, another man not having a certificate, which one to prefer?
Your lordship, moreover, your lordship,
But in any view, he got more more marks than you. You do one thing is
your
still in
lordship,
2016 matter.
Yes, Latif.
He has been in continuous service, my lord.
Who?
he ought to have.
Yes, number 6.
Your lordship, if the marks are,
No.
even if your lordship, the mark for library science is not counted, your lordship, he ought to have get, your lordship, the private respondent 108.52, your lordship.
Have you challenged it?
Your lordship, I have stated in my petition, your lordship, I have challenged it, your lordship.
the comparative statement, your lordship.
But this is not the complete records.
This is not.
Therefore, we use the word
That
complete record,
yes,
because this document is available, is annexed also.
records
So
are
why
not-
do you produce a document which is already annexed?
May I, your
The records are not available. That is what I have found. Lordship.
If not available, then how will you justify somebody's selection without there being a record? We have to cancel it, redo it. Both of them. And till you redo, he'll continue.
Yes. That is what- yes.
That is the only way out.
your lordship, as per my
Just a minute, Mr.
lordship.
We are taking up the cause on your behalf only. Why are you,
No, your lordship.
you want to
your-
argue? Okay, argue.
No, your
Very
lordship,
well.
just,
Start.
as per my,
From the beginning. No, sorry.
I beg pardon of your
You
lordship.
did not beg. You start from the beginning. We'll hear you.
Your lordship.
Say whatever you
the
have to say.
Selection process. might
And
have-
if your submission is good enough, we'll interfere. Not good enough, we'll dismiss the petition. Start.
I beg pardon, your lordship. Your lordship, as per my information, this selection process has been dropped, perhaps, your lordship. I have not been communicated as per
So
my.
how do you depend on a informed statement? File an affidavit,
No, your lordship, it's.
Mr. Your name?
Yeah,
Yeah, I mean, it states that according to his information, the selection process by which the respondent six had been appointed had been dropped. Petitioner may file affidavit as regards the same statement. List
they have
again.
to bring record, your lord, if the information. 26.
No, you were going in a different line, Mr. Now.
I thought to your lordship, inform your lordship, but the other.
How can an unsubstantiated information be a basis of a court direction? Can it be under any circumstance? Then we're allowing you to rely on your what allegation, you file affidavit. We'll take note of it.
Other side may also bring record, your,
Why-
bring
why?
inform,
No.
up to your lordship.
We cannot make a roving inquiry just because somebody makes a statement. Make the file the affidavit, then we'll issue notice on the affidavit, we'll hear them on it.
Maybe.
Why did you spoil your own case for
Your
nothing?
lordship,
What
I
to
thought
do?
to, I thought to inform your lordship,
Please understand that fault is on us. You
Why?
wanted to inform us something unsubstantiated and you want a court order based on an unsubstantiated statement.
Your-
Very well. We are likely to have gone in a favor even without that statement.
I beg
Next.
pardon.
Okay, file your affidavit now.
26.
Mr. Ahmed. There is an art of lawyering also. Please take note of
I'm
everything
extremely
and make
sorry,
your
lordship,
submissions.
I have interrupted your lordship.
We are not
I
interrupted.
thought it's my.
You had
duty
made
on
a
my
for-
part to inform the
You are
court.
not interrupted. You have made a formal statement before the court and we are want you to file an affidavit of that statement. That's all.
Lordship, oblige.
That's Mr. Tor.
This is a contempt petition and
20
this has come for the first time.
26 need.
This come for the first time.
Contempt, which order is violated?
My lord, on
Page
page
number,
11,
direction.
page 14 is the upper.
Pension.
Paragraph 13.
Mr. Chisti. Ask the principal in charge of Women's College Silchar to remain present. Thursday. Inform her. See, it's a direction to pay provisional pension. Not paid.
Not paid.
Why do you not, why the principal not pay the pension? And we'll do one thing, we'll stop the salary of the petition principal also. Hire somebody. The director of higher education also to make an inquiry and submit a report before the court as to why the provisional pension to the petitioner order to be paid as per the order dated 18/9/2023 in WBC 4938/2023 had not been paid. A copy of the order be made available to Mr. S. Das, Land Council of Higher Education Department, list Thursday. We want the principal to remain present. Why, in spite of court orders, you are not paying the pension? Some ego problem. What else? Nothing else.
The copy maybe.
Yes, a copy of this order, and the director also to make an inquiry with the principal and submit a report why it is not paid. Whether there is any legal impediment or you are simply not paying. Principal the principal in charge of Silchar Women's College to remain personally present before the court on so and so to explain as to why the direction of this court in the order this to pay provisional pension to the petitioner had not been duly complied with. A copy of the order. You communicate to the principal also. Duta copy did go. 2 copies of the order. One to take up with the director, one to Thursday.
Item 27.
Mayor, please, there's some mistake, my lord. At the time of filing the petition, we have corrected that name of contempt number 1 in the body, my lord. But in the index, it has not been corrected. That is, I am
You want to do some correction?
Yes.
Mr. B. Raman intends to incorporate certain correction in the petition. The corrections may be done in the presence of the registry and thereafter listed again.
28.
Lordship's order at page 10. And operative part at page 13, my lord, last paragraph. Page 13, last paragraph. Paragraph 6. my lord.
Okay, no, communicate. Heard Mr. Amy Mondal, notice 6 weeks, extra copies 3 days, steps register post 3 days.
29.
Goswami.
May I please, my lord, in the contempt petition, my lord, the petitioner has not been paid for salary for about 4 years, my lord.
This is a contempt petition, first time. Which order, Mr. Goswami?
Starts from page 12.
Which order is violated? Where is the direction?
Page 12.
Page 12.
Operative part is at page 16, my lord. Page 16.
Directed be paid the area salary. Communicated. PK Goswami, Dr. PK Goswami, notice 6 weeks, extra copies 3 steps register post 3 days.
Item 30.
It's 39, my lord, paragraph 34, the common judgment. Operative person.
Contempt, where is the direction?
Page 39, paragraph 34, my lord.
Page
9.
39. Where is the direction?
Paragraph 34, my lord.
34. So now where is the violation?
Another direction, my lord, last page number 107.
Mhm.
Last paragraph.
No, this is only a declaration of the law, but where is the direction?
Last part, my lord, page number 107.
107. Yes, well, okay. We have communicated.
Yes.
Report of
31,
which order is violated, Mr. Gurwa?
My lord, page 7 starts,
No, where
page
is the
17 is the operative part, my lord.
direction? Page 17.
Yes, my lord, because petitioner is supposed to be repaired in the last, so there is a direction to complete the DP within 6 months and to expired in
I understand.
April, my lord.
Okay, notice. What else to do? Or yes, Mr. Where is he? Chisti. Mr. Chisti. Here, there is a DP against this man. There is a direction of the court to complete the DP within 6 months. It is not done. And he is retiring on
My lord, it is January, my lord, I think not.
January.
Yes, one by
And the order is dated 19/4/2023. Instead of issuing notice, we direct the director to complete it within how many days? If necessary, you conduct a day-to-day hearing. Before 31st of December, you complete it.
Yes.
Okay.
Yes, my lord.
Heard Mr. M.G. Burwal and counsel for the petitioner also. Considering the nature of the grievance raised in this contempt petition, we required the presence of Mr. S.M.T. Chisti and standing counsel for the secondary education department. By the order dated 19/4/2023 in WBC 6991/2022, in paragraph 21 thereof, the Director of Secondary Education, Assam, was required to take appropriate steps for appointment of a new inquiry officer. And thereafter, the departmental proceeding against the petitioner be brought to its logical conclusion within a period of 6 months from the judgment. It is stated that the department proceeding is yet to be completed, although the period of 6 months is over. But at the same time, it is also stated that the petitioner would retire from service in the month of January 2024. In view of the imminent retirement of the petitioner from service, we are reviewed that instead of issuing a notice in the contempt petition, the interest of justice would be served on a consequential direction being issued to the Director of Secondary Education, Assam. Accordingly, the Director of Secondary Education, Assam is directed to do all the needful and complete the departmental proceeding against the petitioner on or before 31/12/2023. Contempt petition disposed in the above terms. A copy of the order be provided to Mr. S.M.T. Chisti and counsel for the Secondary Education Department for onward transmission of the same to the Director of Secondary Education.
Obligation.
32,
Yes, sir.
Higher court committee order dated 17/11, your office,
Page number
page 20,
is 20,
page 20, paragraph 20, your office.
paragraph 20.
Call for record from land giving case number 13 of
Huh.
to be court of learned
Huh.
Martinda. That is should have been learned additional 60 to the Martinda. And
Heard Mr. L. Mohan, consider the applicant. No, any state who appears, government. You were there.
it's okay.
Sorry,
Please, I can.
where is he?
Court number 13.
But we are court number 6. So how can I record his presence here when he is present there? Ask him to come. If he comes. He's like our deputy commissioner in Sukia. This entry application is for correction of the provisions in para 20 of the order dated 17/11/2023 in WPC. In CR, in CRP IO 182/2023. By this, by para 20, the records of land grabbing case number 13/2015 from the Court of Learned Munsif Margherita was called for. The said order be now read to be for calling the records of land grabbing case 13/2015 from the Court of the Additional District Judge Margherita and not Munsif Margherita.
Small mistake is in the cost title of the my original petition. In respect of respondent number, name of respondent number 2.
The incorporation in the correction in the cost title cannot be corrected by means of the present interlocutory application. However, IA allowed in respect of calling in respect of the aspect of calling for the records of land grabbing case number 1321 from the Court of Additional District. Yes. There you have to amend the writ petition.
Only one,
Mr. Mohan, the reason may be very innocuous, very simple, but the procedure is you have to file them. We cannot correct our order. Plus, the name of the parties in the certified copy is not a part of the earlier judicial order. It's an administrative order based on the records of the High Court. So you correct the cost title in the CRPIO, then it will be corrected.
Item 33.
Yes.
Your Lordship, directed the Guwahati University to fund on
PJ Phukan affidavit has been filed, but the same is not on record. Where is Mr. Phukan?
he just informed me for 10 so 10 minutes will be there required, coming, madam.
So he said, ask the way to cook. Wait for 10 minutes, I'm coming. I'm on the way. Anyone on the unavailable to Mr. PJ Phukan, Learning Council for the Guwahati University, list again.
Next. 34 for hearing.
34.
Lordship,
This
in this
matter
case, my
is agreed list on so and so parties are presented. Wait,
This
hearing,
yes.
Ready?
School of the.
are you ready?
Lordship, on the last occasion, Lordship asked us to procure the.
No, on the last occasion, only as agreed by the parties list on so and so, that was the order.
Lordship, the provincialization order, the authorities have not received it. The first provincialization order, Lordship.
No, I don't know.
Lordship, the school.
No, but
of
if
the-
I hear for 15 minutes and then again enjoy,
Yes.
it's a wastage of time for everybody's time. So if I can hear, complete the hearing, please start. And if I cannot hear, let us fix another date.
Lordship may fix another date, Lordship. Thank you.
You take up between you two,
Friday,
take a date.
Lordship, I have got no issue.
Friday.
I'm here till 14th,
Yes, my lord.
no
Friday-
difficulty.
This Friday, let me this Friday.
Okay. Subject to how many cases are there on that day?
Friday or morning.
Thursday.
List on Thursday is paid for. Yeah, and what do you want to bring?
Lordship directed that the first provincialization order when the school was provincialized, because one of the teacher has not been provincialized with regard to the subject.
But school was provincialized under the 77 Act.
77.
That's why we wanted 77 across the board, everybody is provincial.
Yes, Lordship.
2011 onwards, it started that some are provincial, some are not. 2017, again, same thing, but the criteria are changed.
Yes.
Earlier it was seniority, now it is depending on some different criteria. So if the man is in 77, I think we examined the law 77 Act or 75 Act. Act is 75, I think. Rules are 77. Everybody is, I think, deemed to have been provincialized. I think that's right.
But one of the.
The respondents to produce the original order of provincialization of the name of the school,
Nalbari ME School. Lordship, one of
Nalbari
the-
ME School, on the next date of hearing.
Lordship, but I joined in 92. School was provincialized in 70. I should point out to your lordship.
Joined in 92.
School was provincial in
And
70.
no, I understand, 92. In what
In this
process?
section,
No, in what
the
process?
picture.
Understand, in what process? Advertisement,
managing committee has.
advertisement.
Hey, you got the hand.
Was it a vacant post the day you
Lordship,
joined?
lordship, because while the school was provincialized, the post was there, Hindi teacher.
Post was there, but no person was there.
Yes.
Then I think we have to be recruited by following the rules. This
But
check,
since, well, one of the,
no, no.
yes,
Had
one of
you,
the final point.
had this man existed in the school as a teacher in 1977,
Yes.
he would have been provincialized
my
as per
lord,
the act.
yes, my lord.
That's by operation of
My
law. You don't need anything beyond that. But if I understood rightly, in 77, this post was vacant.
Yes,
And
post is shown, my lord, post is.
post has to be shown for provincialization, but no one was provincialized because the post is, no one is occupying the post.
Yes,
Now, that means after 77, this is a available vacant post in the school for recruitment under the recruitment rules.
yes.
So that means the regular process, advertisement and selection, etc.
That's true, your lordship, but one of the
No,
final
no,
point.
I understand.
yes.
No, final will go little later. Let's go to the rough points first. Was there any advertisement when you were appointed, and who appointed you?
Governing.
Governing body will not have a
But lordship,
jurisdiction.
final point what I wanted to
Yes,
submit also.
now
it
say
was
the
against us. Lordship, but because the Hindi section was not provincialized, it was a sanction.
No,
Then
no,
after,
post was provincialized. Only thing, no one was occupying their post. If I understood it rightly,
my lord.
that means it is like any other vacant post available in a provincialized school.
School.
That can be filled up only by the recruitment rules, not by the managing committee.
But my.
Please examine
yes,
this one. It will
yes,
go
yes,
against
I
you.
mean, this is submitted before.
Understand?
Unnecessarily
So
they-
how do you intend to overcome this
Yes, my
difficulty?
My lord, since the section was not this one provincialized, and it was it's on a venture stage. Let us see, my lord, because thereafter it was sanctioned. The section, Hindi section. The
On which
subsequent-
date it was sanctioned?
It was later on section. May I take your lordship? Lordship 93.
What's a post was sanctioned in 90?
93 Hindi section. According sanction every section 1192 to the
Mr.
number 2.
Chisti, possibly that principle will not be applicable. That managing committee cannot make appointment in a provincialized school will not be applicable, because that will be applicable in respect of those posts which are already provincialized. Sanction posts. Here is a case, school was provincialized with 10 posts. In 93, one more post is sanctioned. Okay, which is not provincialized. Let us see the sanction order, how it
Lordship at
reads.
page 19.
19.
Borrow.
Below mentioned videos are accorded sanction approval. What do you mean by this order?
Lordship, my understanding is that they were allowed to open additional section after getting the permission from the SEBA.
So this post is sanctioned.
Yes,
So now in a province school which is already provincialized, one new post is sanctioned.
yes.
And where is your appointment order?
My appointment letter, it is page 15, my lord. Thereafter, it was regularized, your lordship.
Which order?
My lord. My post is also sanctioned, page,
The post
page
is-
21. Page 21, my lord.
Just a minute. No, where is the sanction order? You say just page 19.
Yes, my lord. Borrow medium section.
Mr. Chisti, I think she has some case. Because her appointment is prior when there was no sanction post. Okay. That becomes the prerogative of the managing committee. The principle that managing committee cannot appoint in a provincial school will hold good when it is appointment against a sanction post. So later on, post was sanctioned page 19, 1993. In the meantime, this person is already working. So as this school is governed by the Act of 1975, why not the same principle will be applicable to this man? 95 Act concern, in 75 Act.
75.
Had your sanction been prior, appointment later, I would have straight away almost rejected it. Huh? But appointment is prior, sanction is later.
283.
So there is no bar for a managing committee to appoint anybody against a non-sanctioned post. He cannot do it only against a sanctioned post. But later on, when the post will be sanctioned, and if the school is already subjected to the 74 Act, why not the same provisions will be applicable in this case? I think she had made out some finer point.
Lordship, it has to be verified because this appointment process was before bifurcation of BGC area. So
No, no,
some-
still, whatever it is, that will not change the context. Because the person was appointed on 8/2 as per resolution, when there is no post. Managing committee feels that we need one Hindi teacher, no post. We appoint somebody. Same is the situation prior to provincialization. According to requirement, can they do it? Now, after the sanction is there, she'll also be subjected to the 74 Act. Why not? Why do you rely on the other proposition that managing committee has no power? Managing committee has no power to appoint only against a sanction post.
Of the cases of other persons were considered only, I was dropped.
Where is the principle that a managing committee has no power to appoint in a provincialized school?
That's the decision of this honorable court is there.
Can I have that?
Yes, I have to be this.
uh,
Jahangir and Abdul
Let us take a look at that proposition, what it means.
It was regarding in a provincialized school law.
I think it is against a sanction post. Because sanction post, what happened, sanction post can be filled up only as per the rules.
Yes.
Not by the managing committee. So therefore, this proposition is laid down. But when there is no sanction post, managing committee feels that there is a requirement of a Hindi teacher. So they appoint somebody. So for the time being, the post becomes as if it's a post in a venture school. Later on, when the post is created, why Act of 1974 will not be applicable straight away? Because this is a pre-existing employee in a post on the date when the post was taken over by the government or created by the government.
Anyway, Lord, they kindly grant us sometime, we have to construct a file also, we don't have the records also. Any next Monday or Tuesday, Lord. And Tuesday, Lord, again.
Thursday.
Thursday, this Thursday.
No, next Thursday.
Next Thursday. No, I'm copy na, I'm why na,
Tuesday, we have no interest. Next Thursday.
Come with last Thursday or Friday, this Thursday or Friday, madam.
Anyway, this Thursday.
When?
Thursday, this Thursday.
Today is Monday.
Very good. You are already learning.
That may not be normally.
Hetu thako. Full stop. A question of law for determination has also arisen inasmuch as the petitioner was appointed by the managing committee by the communication dated 8/2/1992, page 15 of the writ petition. Later on 19/1/1993, by the order of the Additional Director Elementary Education Assam, the post against which the petitioner was appointed as a Hindi teacher was sanctioned. In other words, the appointment by the managing committee is prior and the sanction of the post is subsequent. In the circumstance, whether the principle laid down by this court that the managing committee has no power to appoint a person in a provincialized school would be applicable. More particularly, in the background of the factual situation that the appointment of a petitioner was prior and the sanction was subsequent, and it is not a case that the managing committee had appointed a petitioner against an existing sanction post in a provincialized school. Further, whether in the given circumstance, the provision of the Assam Elementary Education Provincial Act 1974 would be applicable. This Thursday for further consideration. Mr. Talvida Lengo Harry states that the record required by the order dated 23/11/2023 could not be made available today. Adjournment for 1 week is sought for producing the records. Pray aloud, list after a week. List next week.
36 for orders.
Or 36 years, what is this matter? Review. Well, yes, I think we asked you some questions. Yes. Mhm. Huh. If I allow your review, we'll draw a presumption against all arbitrators which are included in their panel of arbitrators. It will be applicable across the board. Why should we do so unless you have specific material against a particular arbitrator? Say this particular particular arbitrator may be included in the panel, but again, this man, we have grievance for XYZ reason, whatever it is. We'll hear you. Sorry. Huh. Ramesh Chandra GM so and so, where involvement connection was entered between the President of India, C. Shillongjong and Siang Enterprises. Okay, then 6. Now, therefore, whichever project containing clause in terms of the arbitration, the engineering chief has appointed you as the sole arbitrator. Yes, very well. Sorry. Show the judgment, what you want to rely on. Judgment of which court? Supreme Court. What does it provide for? Paragraph number? No, that we understand. We know how to read the names. Which paragraph you are relying on? 27. Let's read. If you're right, we'll accept it. Here is a case, choice given to the opposite party is limited. Choice given to the opposite party is limited as it has to appoint somebody from within that panel.
I'll bring attention to one line, that is 8th line. Secondly, with the description given,
To choose 5% from a room of suspicion is created in the mind that may have picked its own favorite.
we have not received the panel.
Sorry.
In regard to this particular line, I submitted, we have not received the panel list, subject to correction, I would say, we have not received the panel list, the list of arbitrators, the entire panel. So it was appointed by the engineering chief.
Where is the order of the court?
Page 19 of the review petition.
Do one thing. If this is so, we say arbitration fails, you go for civil suit. Face a civil suit then. What else to do? You are only avoiding arbitration, nothing else.
To appoint somebody from the High Court panel.
How can you have your discretion that you will only have a High Court panel? Where do you get it? In that case, you ought not to have entered that arbitration agreement with the other one. After having openly agreed to that one, how can you now say, I don't follow that one, I want a High Court appointed? We can appoint, no difficulty. But the difficulty is, we will cast a doubt on every arbitrator panel maintained by the government of India. That means it will be a general order that all arbitrator panels maintain, do away with it. It is only the High Court who is going to appoint. And these are arbitrations of some technical nature. Some arbitrations are of issues are law-based issues, where a legally trained arbitrator is more competent. Is it not so? That's right. Some arbitration disputes are very, very technical. A competent, legally trained person may not be able to perceive it. So therefore, there is a set procedure that we have maintain a panel list of arbitrators. And they appointed one of them. So until and unless you bring in some material that this person appointed, Ramesh Chandra, he is a biased person, or he had dealt with this matter at some stage earlier, he is incompetent. If that is so, we'll interfere with it. That's no difficulty. But what you were trying to say now, that in general, it's almost like asking the court to lay down a law that all panels of arbitrators maintained by the government authority give a go-by to everything. Appoint only High Court appointed arbitrators. This is where we are finding it little difficulty. And this line is created a mind of the other side may have picked up its own favorite. If that creation has come to your mind, please substantiate it. We'll hear you. We'll not only hear you, we'll also set aside that appointment of that man as an arbitrator.
There is one more that can be done.
Otherwise, these arbitrations, you better forget about arbitration, go for civil suit. That's why I say.
No.
We'll tell them that one of the parties has frustrated the arbitration clause. So we refuse to appoint anyone. You are at liberty to go for civil suit. Right?
That will also not go against the department because it's our arbitration.
So if it is your arbitration, your suit will be by you. What is the dispute?
My lord, the contractor failed to perform the contract, and due to the failure, we have to get the work done to the other contractor.
Why do you go for arbitration? Why do you cancel it?
No,
What
we have
prevents you
cancelled
from-
it, my lord, under the contract, the cost
Once you have
incurred-
cancelled it, at his risk and cost, allot the work to somebody.
Yes.
Why do you want to go
That
for?
risk
You
and
go.
cost, my lord, we are claiming. The
Sorry?
department risk and cost which has incurred to the department, now that is being claimed under the
That is being claimed.
claim under the arbitration. Because we have got the work done to the other contractor due to the failure to perform the contract. Now the cost which we have incurred, my lord, that cost.
That difference of the cost.
Yes.
You want to recover it.
On the contract.
So how is it a part of the arbitration then? Let us see the arbitration clause. File a civil suit, get an attachment order of his properties. And Mr. Counsel for the petitioner, this objection ought to have been raised in the arbitration proceeding before the court itself for appointed. Yes, we have some apprehension against this one. We are objecting to it. You did not raise it.
Section 13 is there, my lord, the challenge procedure. because
Page
the-
number?
my lord, the proceedings are already started.
No, no, even if it is started without jurisdiction, we can always go. But where is that arbitration clause?
But page 246, my lord.
246. Hmm. 246, cancellation of contract in part or in full for contractor's default. He has not challenged this
No,
one.
277, I'm sorry, my lord.
70.
277.
77. all disputes between the parties to the contract, other than those for which the decision of CW or any other person is by the contract expressed to be final, shall be after written notice a party to the contract to the other of them be referred to the sole arbitrator or ban serving officer having degree in engineering or equivalent or having passed final examination of subdivision 2 of institution of survey recognized by government to be appointed by the authority to be mentioned in the tender documents. Unless both parties agree in writing, such reference shall not take place until the completion of the alleged completion of the work or termination. Anyway, Mr. Gupta, if you ask me, I'm never in favor of these arbitrators of this nature. Not because of they may be biased, this, that. The reason is, these people, they do not know anything about law. They know only technical as to how to measure, how to this, how to do that. Now, whether suppose it's a case of termination, whether there is a violation of the stipulated clause, etc., it's a legal issue based on evidence to be produced. It's a case of interpretation of evidence. It's a case of understanding the propositions. Engineer is not well trained for that purpose. Engineer is only well trained, suppose it's earth filling, to find out whether 80 meters had been filled up or 70 meters had been filled up. He's an expert in that. And most of these engineer arbitrators, we are having difficulty in adjudicating. They don't go into the legal issue, they go somewhere else always. So for another reason, we are always in favor of go for an arbitrator who is legally trained. At least that man will follow. Is it not, Mr. Chaudhary? At least that man will follow the procedure. He'll understand the law.
Worship was being my friend. In fact, I have faced the situation. I had faced
Mr. Gupta will hear you, don't worry. No,
I had faced the situation. Maybe last month or so.
Mm.
I was engaged in on the last day. Everything was over. And I asked my friend in the MES, who was one of the party, you file your written statement. Yeah, the written statement, just like as your lordship has said, it was in the form of a letter, no signature, no affidavit, it's filed. Then the opposite claimant filed his evidence. All documents are proved. And my party says, when the arbitrator asked, like, are you going to process that? They said, no, we're not going to process that. Are you going to file evidence? No, we are not going to file evidence. We will show the papers. So what your lordship is saying is correct. They may know how to measure the procedure.
Ultimately, that arbitrators becomes another extended form of that same office only.
No, here it was a
Of
retired
course.
judge, of course, and
Hmm.
the judge was telling me, Chaudhary,
No, it's a retired judge. That's why he raised all these issues. Hadn't before been one of the engineer arbitrators, he would have thought that he forgets about the aspect that he is a retired person. He suddenly feels that I'm again in the department. And let me deal with it how I dealt with it when I was in service. He's right, he is wrong. The basic concern is the fundamentals of legal procedures are,
They don't.
they're not aware of it also. How can you be aware? Suppose you are a legally trained person, he is, we are. Now, if he asks me to repair a huge machine, can I do anything? Can we ever think of? But an engineer will be able to do it. He knows how a machine functions, how it is internally, what is the actually happens there. Similarly, when you ask that same engineer to decide a legal issue, how do you expect that he is such an expert that he will decide the legal issue? If necessary, these engineer people can be taken, one of them can be a witness for the department, that he will, technically, he will explain the whole thing. Why the dispute is not maintainable. But ask him to decide a legal issue. Dispute is a legal issue. It can never be an engineering issue. So from that point of view, it's time you do away with these engineers. Or at the best, like those, our CAT and AFT and all, you have a technical arbitrator. 2%. Technical arbitrator who will give you the technical inputs, that this may be like this may be like that, or if from engineering point of view, it is not possible, those inputs he can give you. But the core legal issue should be decided by a legally trained person. Otherwise, it's a encroachment of respective works.
In simple words, it's disaster.
Sorry.
In simple words, it is disaster.
See, now if you ask me, entrust me with a job with the chief secretary, do you ever expect I'll be able to do it? But day in, day out, we are interfering with the orders of the chief justice, the chief secretary. That is something for a totally different cause. We are examining it from the judicially. But we are not trained to run an administration. We can't do it. Same is the vice versa. So I think it's a time these things are done away with.
In fact, the MES, the railways, they
Always they do it. They think it an employment opportunity of their retired people. And nothing else.
MES, I think they have got people from not only MES, CPWD and all those.
That's where that's an interdependence. CPWD will get one from the MES. You take one, give me one. But fundamentally on this, why I'm telling you, about 20, 30 years back, when arbitration was still at the nascent stage in this country, there was a huge prevalence of this technical person being only arbitrators. Everybody thinks that they are the only one who can become an arbitrator. Because initially the disputes were basically how much work I have done, how much work I have not done. For this much of work, what ought to have been my bill? But nowadays it has gone to a different level. And ultimately we are settled with these arbitration awards, which is neither here nor there. And ultimately the whole system is, and against this order, they'll go in appeal to the district judge. District judge will again start judicially examining the order. One line is there, where is the material on evidence, whether this evidence is admissible, he'll start venturing into that line.
People looking at the very limited scope.
Whatever it is, he'll make a judicial application of mine. He won't make something beyond judicial application of mine. District judge will not going to substitute himself to be an engineer and then start looking at the matter. Here the conflict comes. Supreme Court therefore says that a room of suspicion is created in the mind of the, he may have picked up his own favorite. We are not on that because you are casting some aspiration on some person. One person is already appointed. We don't want to cast any aspiration on that man. But about the otherwise. Why don't you appoint this thing? They appoint some lawyers as arbitrators.
In fact,
It is prevalent.
lawyers
As a
are-
lawyer, I remember I conducted some arbitration proceedings.
lawyers-
And ultimately, those orders were such unbiased orders in a way, both the parties agreed to the settlement also. In fact, it was an element of mediation also crept into that. Both of them were explained that this is what you intend, this is what you're not. Other one said, once you, in course of deliberation, once this is made understood to both the parties, they also agree, yes. Okay, let's settle for that, whatever I'm entitled to. So the dispute resolution is much faster. See, now is a case, department wants to initiate a proceeding. What is the date of that initiation?
Arbitration.
Not the arbitration. Since when you intend to pursue with this arbitration? Must be about 2-3 year old by now. Definitely has to be. Order of the High Court itself is 1 year old.
22, my lord. 2022, my lord, appointment was made.
That a High Court made. That means your decision to appoint an arbitrator was much prior to it. Your intention to go for a dispute was much prior to it. Definitely before the High Court order. It cannot be after the High Court order. So 2-3 years have gone by in this only. Whereas it is supposed to be a more shortcut and this thing, not shortcut, it is supposed to be a faster remedy. Had it not been there, had we been a title suit, at least some progress would have been made in the suit by now.
One thing may I suggest, my lord, as my friend, he's agreed by, from the panel, my lord, the grievance is that we have chosen a particular person as the arbitrator. Let there be any other person, my lord, from the panel can be appointed. If not
So he says he wants a court arbitrator appointed
one
arbitrator.
from the panel. That would be
Then
again.
let us appoint a retired district judge, whoever is there.
In that case, my lord, the confirmation of the panel itself, my lord, that would, because it's
That's the first question I raised to the
Yeah.
learned council. That basically it will cast an aspiration on the entire panel list. We don't want to do it. But why do you bring this kind of panels? That mindset of 30 years back, why don't you come out of it? And your arbitration clause also. All disputed shall after written way refer to sole arbitrator or when serving officer having degree so. So why are you
my lord, this we have not followed, my lord, because after, this is an old agreement, my lord.
understand you are not followed, but what you followed is also nothing better than this.
No.
It's almost of the same level. Instead of a serving officer, it's a retired officer now. That's the only difference. Means we are asking you, why do you need a departmental officer? Why don't you go to a legally trained person who will be much better, much faster, understand the problem wholly, and wherever there is a necessity of any technical information, the arbitrator can appoint any technical person for assistance. It's permissible. Why only that engineer, in other words?
Present case, my lord, the question is, what is retired VM? He's the
We are not on the person, we are on the category of the person. Where is the Arbitration Act now? What does it provide for? Which is the provision for incorporating arbitration clause?
seven, my lord.
7. What does it say? Any provision on what is the expected eligibility and qualification of a arbitrator? Anything, either by the arbitration council or any authority? Number one. And number two, how do you rule out the apprehension in his mind? There has to be some material before the court to reject his claim that there is an apprehension in my mind. And the basis of the apprehension is that the person appointed, the panel you are maintaining, they are all directly related to the department, either present or past.
My lord, while forming the panel, my lord, if I may take, my lord, to page 292, which contains the guidelines for empanelment.
292, what are the guidelines?
The guidelines contain detailed, my lord, procedure and the qualification.
See, the first there is with a minimum of bachelor degree in engineering. So, number one. Then you read Section 7(1). In this part, arbitration agreement means an agreement by parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship. So when the relationship is, it's a legal defined relationship. All you need is engineer who may not have the expertise even to understand the legal relationship. Second, also retired from or of core engineering sector. So now again, you see you are inviting applications. Meaning thereby you are leaving out a huge number of other eligible people. Wish to get empaneled as arbitrators shall submit application in the prescribed format to the addressee. So you will select. It's a selection. It's your selection. You may not like this selection.
Usually they have agreed.
Uh,
The section 11 code, my lord, they have agreed to it. Now,
may have agreed.
No, it
Now
is-
they are coming in review. They saw that our agreement was wrong. So they went to review it.
whether the review is permissible or not, my lord, in that respect, my lord.
Review permissible, not these are judgments are basically facts of that case.
No, my lord, if I may,
Huh.
my lord. so there-
We are not going into the technical ground. That somehow I am able to manage an order, no more review. We don't have, it's only very. Yes, Mr. Chaudhary. Application, selection. Only the word panel is used, that's all. And whose selection? Our selection. And the code power is section 11.
Section 11. 7(6).
The composition, number 10, the parties are free to determine the number of arbitrators provided that such number shall not be an even number. Okay. Now in this one, are the parties free? A person of any nationality may be an arbitrator unless otherwise agreed by the party. Subject to the parties are free to agree on a procedure for appointing. Free to agree. It's all
Subject to 6, my lord.
subject to
Subclause 6.
6 of
11
where an appointment procedure agreed by the parties,
fail.
a party failed to as required under that procedure, or the parties or the two appointed failed to reach an agreement, a person including an institution fails to perform any function, the appointment shall be made on an application by the arbitral institute designated by the Supreme Court in case of international, or by the High Court in case of other than international, to take necessary measure unless the agreement of appointment procedure provide other means of securing it. Is there any judgment on 11/6? Mr. Gupta, is there any judgment on 11/6? Any Supreme Court judgment on 11/6?
The moment, none.
Because this is one of the questions I asked him, that who asked you to agree to that arbitration clause?
Have not heard it, but he has said, he has doubts regarding the repeated.
Not man, of the panel. I think he has raised a question of panel, not of the particular man. That's what I asked him. If it is against this particular man, tell us the reason. We may ask them to appoint another man. But then again is casting aspiration, no, against this particular person. You have to substantiate it. Otherwise, he'll be a disqualification for that man without hearing him. This is number one. Number two, on the procedure.
Maybe section 13. my lord. The arbitration act.
Section
13.
13, what does it provide?
Not this, quite the challenge procedure, my lord. Subject to subsection 4, the parties are free to agree on the procedure for challenging the arbitration. And my lord, this provides that if there is no procedure, then my lord,
No procedure is okay, but if the procedure, and what is your procedure?
arbitrator, my lord, because once in
No, what is your procedure? Which page is it? That arbitration clause?
277.
277. 77, yes. And then you refer to
13-2.
and who will appoint to be appointed by the authority mentioned? Who is that authority mentioned?
During the appointment of the chief engineer.
To be appointed by the authority mentioned in the tender document. Where is it? Which authority is to appoint?
The engineering chief.
Engineer in chief will appoint.
Yes.
Where is that clause? Yes, Mr. Gupta. Any judgment on the 11-6?
Not directly, all the judgments pertain to the appointment by an engineering chief. That is
No, on 11-6.
why I am aware of that.
Find out. Mr. H. Gupta, then counsel for the respondents, intends to defend the appointment of the arbitrator by the order dated 16/8/2022 by referring to the provisions of section 11-6 of the Arbitration and Conciliation Act 1996, which provides that where under an appointment procedure agreed by the party, an appointment is made, comma, the other party cannot subsequently raise any objection against the appointment of the arbitrator after its appointment. Or to that extent, raise an objection in the proceeding before the High Court under Section 11 of the Arbitration and Conciliation Act as regards the procedure to appoint arbitrator as had already been agreed upon. Any proposition of law laid down in Section 11(6) may be produced before the court. Please count. You also find out. If we can, if it is not binding, we'll look into it. If it is binding, we're out. But otherwise, it's time you look into all this. When do you want?
My lord, on Friday, my lord. Or
Naik, yuk. Thursday. Hari jadi dia, naik jadi naik. Take a date, whichever is available.
37, 40. Much of like. Okay, 37 and 40 are connected method. 38 and 39 are wrongly corrected. And in 37 and 40, lot affidavit is ready, we'll be filing it.
Your for? Oh, that postal department is a person from the postal department.
Yes, I asked.
Just come forward.
The AD has returned in the meantime.
Yes.
Sir, I'm El Rangpol, Deputy Superintendent here.
Your designation?
Deputy Superintendent, sir. Deputy Superintendent of Post.
The Deputy Superintendent in the post.
Yes, sir. Yes.
So High Court is having a difficulty
Sir.
that normally we follow the procedure of steps by registered post.
Right, sir.
We are having a difficulty, the AD cards are not coming back.
Sir.
Ultimately, a way is found out that we go by those postal track consignment or some term you use it, it's available in their website.
Sir.
But that is not admissible in evidence. Ultimately, we don't know whether it is served or not. We only presume that it is served. Once we go in a presumption, later day after the judgments are over, next party comes and say, I was never served. And the postal department, by not doing their duty, it can also be viewed that it's an obstruction of the administration of justice. Because what is administration of justice? Service of notice is an integral part of the justice delivery system. We take help of the postal department because postal department is the appropriate department which the government has put in place.
Right.
Now, if your departmental officials don't do the work, don't you think it's you are obstructing the administration of justice? Everybody is making a hue and cry pendency of case, this, that. If you take out the complete records of the registry, you will find majority of the pending cases, notices are yet to be served. All old cases, you find most of it is not served. Why it is not served? AD card is not returned back. Why shouldn't we put in one of our orders that it will be mandatory for every postmaster of every post office to whichever these notices are addressed to file a report before the registry whether it is actually served or it is not served. And if not served, why you could not serve it? Because most time what happens, your postman possibly throws it away somewhere.
Right.
And everybody forgets about that. We want to curtail this. What do you want to say?
Sir, for this only, sir, our authority, higher authority is also looking to open a new service center here in Guwahati campus, High Court campus itself.
for handling of grievances now. Process is going on, sir. Once we get the accommodation,
Accommodation by the High Court.
yes, sir. Yes, sir. We
It
have
must also
already
register
been
judiciary.
taken up with the authorities, sir.
Kata
Once we get the proper accommodation.
Infrastructure to nalage, eto dilehe infrastructure provision to দিব. Register judicial loko matok, infrastructure matok, aru register general loko matok so. If some space is provided, there will be a nodal authority of the postal department
Exactly, sir. Exactly.
who will inform the court specifically whether it is served or it is not served.
Right. Suppose if we could not provide the AD also, we can give the delivery slip attested one, sir.
No. One report from your postmaster of the post office is good enough.
Right.
If the postmaster says, yes, I have verified the records before me,
Yes, sir.
this notice is served on,
Right.
we'll accept that.
Yes, sir. Yes, sir. We will ensure that one, sir. We can even provide scan copy of delivery slip. because
Yes,
our postmaster.
that will be a good material to accept the service of notice.
Yes.
Now, many people are taking advantage. See what is happening. It is either the postman who is not doing his work. Instead of in the sun or rain walking around such a long time giving it, better throw it somewhere and just keep quiet about the whole thing. Part of my duty of the day is over.
I agree.
To the persons to whom these are intended to, they are supposed to be getting notice from the court. Many people likes to avoid court notice because they will have somebody has filed a case against them. Either manage the postmaster or do something about it regarding the service. This is one of the major way of frustrating. 3, sometimes even after due diligence, either the address is not found, he is not there, or something other happens. First and 2 should be avoided. Third one, we can take care of. If you get a proper report from the postal department that this addressee does not live in this designated address, it's good enough. We'll come back to them and say, provide the correct address and take steps once more.
Noted. Will help you.
But if you intend to put up a nodal authority, I think it will be good. Let us ask
Sir,
the
that-
registry whether
that-
to what
that is
extent
an
that will
consideration, sir. We have
serve the
already-
purpose.
Sir.
And I would like to request you to sit with the registry people and work it out.
Okay.
And after 2 days, we'll list it once again and see what report comes back. Otherwise, it's a perennial problem. Sometime back, those General Clauses Act was followed. But General Clauses Act, why it is not maintainable, if you read the act, there is an opportunity to the other side to object to it. Here, the person to whom the notice is sent has no opportunity to object. So 27 presumption is not applicable. It's a huge problem actually for the judiciary in the court system. If we can activate the notice delivery system and make it more purposeful, lot of time will be saved in the litigation. And if you want, you need some more money, you can take it up that no, for postal deliveries, we want some more charges. Take it also if you want, but ensure it. You can take up, that is your prerogative, that you increase the amount of stamps required if you want. If you feel that this money is not adequate for us to do the work, take more money.
Yeah, sir, that tariff could not be regularized from here, sir. It's from all India.
Which one?
Increasing the rates.
Do it. Take it up departmentally, increase it. You'll be paid whatever you want. But the service in return has to be immaculate. That's all. And even if you don't pay, you are doing a free service, still it has to be immaculate. Okay. Otherwise, we are suffering, everyone. আজি আমাৰ জুডিচিয়েলত লাগিব গোটেইকেইজনে আহক নেকি Of late এটা problem এটা পাই আছিলো, registered judicial is also aware of it, তেওঁ আহক, registered general আহক, service of notice or ওপৰত. Ultimately, you are going to that postal track consignments on that matter. Very only, you will take up a little later. Or you can take it up in the chamber also, if he comes. Right now? Okay, this doesn't need any open court deliveries. And now in this case, what do we do? Yes, Mr. Tawilder? The matter that is called, what do we do?
37 and 40. Affidavit is ready, we'll be filing.
37, 40 likho, Air Tawilder states that the affidavit is ready and it will be filed within
Tomorrow or day.
within 2 days, list again. It duta beleke. And the others,
38 to be segregated, my lord.
38 to be segregated. On the prayer of Mr. G.A. Borghuni, like a petitioner segregate item number 38, by petition number to be listed separately. Any other? Over.
Item number 13.
Postal service, that will take. In all the, yeah, regarding postal service, after we put up a system, take service once more in a correct postal address. It will be very strong. Putting in the material. And once we agree on something, I'll.
Timing item 4.
Some information was brought up.
What was this matter?
Compassionate appointment.
What information was sought for?
About the information that is at page 20. Poem date number so and so dated
Page 20
20, yes, ma'am.
20.
Yes, ma'am.
Ha, 260. What is that? X. No, anybody to be appointed on compassion as teacher, they also must be TET qualified. It provides for that. Oh. But anyway, he is not qualified for a teacher. So that doesn't matter whether he is TET or not. So examine him against any other post he is entitled to. Third, Mr. Upaithe, well, counsel for the petitioner. Also heard. He said, yeah, one is Pegu. The father of the petitioner, Vishnulal Joshi, bracket New Pani, who was an assistant teacher at Kodamoni LP School in the Biswanath Chariali district, died in harness on 8/4/2013, and on his death, the petitioner submitted an application for compassionate appointment on date of your application.
Hello, 3/6/2013.
6
3/6/2013.
3/6/2013, the said application was placed before the DLC of where is the DLC?
TLC I have not been given the.
Was you made some
TLC is
reference,
20 to 420.
page number?
Para 7 we have indicated.
She simply made a statement.
Yes.
Was placed before the DLC of Biswanath district
Yes.
or Sonitpur,
Biswanath,
Biswanath district, in its meeting of
22/4/20.
22/4 Sorry. 22/4/2000,
22.
22/4/2022.
Yeah.
And was recommended for a post of assistant teacher. When the recommended DLC was placed before the SLC in its meeting on 28/8/2022, it stood rejected by providing the reason of non-availability of NCET norms, and also that the petitioner does not come under the purview of the OM dated 2/6/2017, and that his higher secondary marks is below 45%. We do not notice any infirmity in the rejection of the SLC, inasmuch as the petitioner may not be duly qualified for the post of an assistant teacher. But a law of compassionate appointment is not an application against a specific post, but against any post to which the person may be qualified for. From such point of view, there is a requirement of the DLC to re-examine the application of the petitioner for an appointment against any other available vacant post in any department for which the petitioner may have the necessary qualification. Accordingly, matter remanded back to the DLC of Sonitpur Bishwanath district to be again placed in its next available meeting for consideration as indicated above. Okay.
Item 6.
Yes, Mr. Hazurika, what? Two days time. List on so and so on the prayer of Mr. P. Shaikyal and counsel for the Deputy Commissioner of Kamrup.
Obligement.
Item 18.
Mr. Chauhan.
My lord,
Rest time.
petitioner who is physically handicapped person, my lord, having 40% low vision category candidate. He applied,
Physically handicapped.
yes, my lord. He applied for the post of grade 4, my lord, pursuant to an advertisement dated 25/3/22. Thereafter, he got selected, my lord, and appointment order was also issued in his favor.
Was selected and appointed also. And now,
Yes,
now what
And,
is it?
my lord, thereafter, by order dated, my lord, 35/2023, my lord, kindly page 41.
41.
41, yes. His appointment is kept on hold. my lord.
I think we have passed some order in this kind of cases. Sorry. Other petitions. It'll come on Friday. Any idea of the red petition number? List along with WC so and so on Wednesday. I think we have already, in a similar matter, we have issued, they want to say something. But otherwise, how can you put it on hold? How can you do it? Understand, how can you do it? Under which provision of law? No, why do you doubt a certificate relied upon? No, but across the board, how can you do it? Okay, somebody, date of the certificate was disabled, but as of today, he may have improved.
Let's see, kindly see, my lord, page 26.
No, we know, we are aware of this. This is one more similar petition is there. And this is a disability of what nature?
Low vision category.
Low vision.
Yes.
Do you mean to say after the certificate was issued, the vision of this man improved? Locomotor disability, we understand that today somebody, some physical disability is there. Tomorrow his disability may improve, that he'll be of a lesser category of a disability. We understand that. But in how many cases a low vision, and low vision from birth or had in between?
By birth.
By birth.
Yes.
How do you expect after a few months, low vision by birth will improve?
Only just to
Is
put
there
30
any
days.
medical phenomena? If there is no medical phenomena, is your decision to go for review not arbitrary? Across the board. Selected man, yes. Say, Mr. Pegu's thing, we have some doubt because of this one. We want to send it for re-verification. We understand. But how can across the board everybody will be sent for re-verification? Is that decision itself not arbitrary? Anything, and moreover, one legal principle is against you. A specific order or a specific provision cannot be done away with by a general order. So there are specific certificates of the individual persons. You cannot do away that with a general order that I am not believing in those certificates. Now I'm going to make my own verification. That doesn't provide you that. But at the same time, if you have doubt that somebody is fraudulently claiming and have materials and reason to doubt it, you take individual action against that man. Not that the entire 40, 50 people will be lined up. They are already suffering. Do you know the sufferings of a disabled person? You are fully able, so you don't realize it. Have you ever thought it from his point of view? After a great struggle, he got one job. Why do you trouble him more? Are you not degrading him? Are you not degrading a disabled person who is actually disabled, facing all the inconvenience in this world from birth, to put him in a disgraceful situation that I doubt your certificate, now I'll examine you once again? Why do you do it? So you scan through the entire list of 40 people. If you have doubt that somebody has given a fraudulent certificate, pick up that man, subject him to. We don't mind. We'll allow you to do it. And that too, we don't know how long it will take now. Now your authorities, it is under their control. Whenever I want, I'll constitute a medical board. Till then, this violates the Disability Act. So suppose in a locality, there are a lot of theft cases. Can you take the entire locality to police custody? And there are so many theft cases here, arrest everyone. Now I'll investigate and verify one by one who is a thief and who is not a thief. Can you do it? No? Are you not adopting the same procedure? And mind you, these are all genuine, authentic certificate issued by a competent medical authority. And how can your appointing authority overrule everything? Day after tomorrow. Come ready with all the arguments. Mainly, we are concerned that by a general order, you cannot overrule the specific ones. There is a legal principle. Find out that decision. It is there. It will go in your favor. Discount here, no? Or else you do one thing. You give us a list of all amongst these 40 or 50 people against whom you have authentic material leading to a reason to believe that he is making a false claim. We'll allow you to segregate those people, and the rest of the people you proceed for their appointment if you have no material. I think so. Suppose a man has acquired disability say a few years back, acquired a certificate. Maybe that disability, physical disability have improved in the meantime so that the level of the disability has gone down. You may be right. But a man with low vision from birth, do we ever expect him to improve in the last 3 months after the certificate? Hmm? And what a difficult life he is leading. Have you ever thought about it? Give some sympathetic consideration to the disadvantaged people. It's very difficult to lead a life of a disadvantaged people, mind you. When everything is okay, those people never realize. A man whose kitchen is always full never realizes what hunger is. Only a man in the street who doesn't get to eat for 2 days, he knows what is hunger. And you doubt that person also.